They therefore decided to ask the Attorney General, through the Acting Director of Public Prosecutions, to authorize them to offer Blunt immunity from prosecution if he both confessed and agreed to cooperate in their further investigations. I should like to pause for a moment on this question of granting immunity, because I think that there may remain some misunderstanding about it. It is not unusual for the Attorney General to be asked to authorize immunity from prosecution in return for cooperation in the pursuit of inquiries. It happens from time to time in the course of criminal investigations. Under our constitutional arrangements, the decision is taken by the Attorney General in his capacity as a law officer. He takes it on the basis of what, in his view, is best in the public interest. He may consult his ministerial colleagues, but he is not bound by their advice. The decision is his alone. In this case, the then Attorney General, Sir John Hobson, decided that it was in the public interest to offer an immunity from prosecution. In fact, to this day, there is no evidence which could be used as a basis for prosecution against Blunt. So the offer of immunity was made. Professor Blunt confessed, and both at the time of his confession and subsequently, he has cooperated in the inquiries of the security authorities. He's provided information about Russian intelligence activities and about his association with Burgess, Maclean, and Philby. After the Attorney General's authority to offer immunity had been given, the Queen's private secretary was invited to a meeting with the permanent secretary at the Home Office and the Director General of the Security Service. The Queen's private secretary was asked to the meeting because Blunt had since 1945 held an unpaid appointment in the royal household, for which he'd been awarded a knighthood in the Royal Victorian Order in 1956. At this meeting, the Queen's private secretary was told that Professor Blunt was suspected of having been an agent of Russian intelligence, but that provided he confessed and cooperated in the inquiries of the security authorities, he would be granted immunity from prosecution. The Queen's private secretary asked what action the Queen was advised to take if Blunt confessed. He was told that the Queen was advised to take no action. Any action would, of course, have alerted Blunt's former Russian controllers and others who were already under suspicion to the fact that he had confessed and could well be providing information to our security authorities. After Blunt had been interviewed and had confessed, as I have already described, the palace duly followed the advice that had already been given. I turn now, Mr. Speaker, to the question of how ministers were informed. Relations between the Security Service and ministers are governed by the directive given to the Director General of the Security Service by the then Home Secretary, Sir David Maxwell Fyfe, in 1952. It's reproduced in Lord Denning's report of September 1963. When discussing and endorsing the principles embodied in that directive, Lord Denning said, and I quote, "The head of the Security Service is responsible directly to the Home Secretary for the efficient and proper working of the service, and not in the ordinary way to the Prime Minister. The head of the Security Service may approach the Prime Minister himself on matters of supreme importance and delicacy, but this is not to say that the Prime Minister has any direct responsibility for the Security Service. If the Director General of the Security Service is in any doubt as to any aspect of his duties, as for instance when he gets information about a minister or a senior public servant indicating that he may be a security risk, he should consult the Home Secretary. The Home Secretary will then have to take responsibility for further action. All of that has been quoted from Lord Denning. Mr. Speaker, I can tell the House that in the case of Blunt, the Director General of the Security Service followed scrupulously the procedures which had been laid down. He had a meeting with the Home Secretary on the 2nd of March 1964, in the course of which he told the Home Secretary about the new information implicating Blunt, and he indicated that he would be discussing with the Director of Public Prosecutions how to conduct the interview with Blunt, bearing in mind the Security Service's need to obtain as much intelligence as possible about Soviet penetration. The Home Secretary drew his attention to the need to inform the Queen's Private Secretary. On the 17th of June 1964, a further meeting was held between the Home Secretary, his Permanent Secretary, and the Director General, in which the Director General reported that Blunt had admitted spying for the Russians throughout the war when he was serving in the Security Service. The Home Secretary of the day, now Lord Brooke, who at first did not recall being told, which is quite understandable.
The records are all there.
I'll start the sentence again, if I may, Mr. Speaker. The Home Secretary of the day, now Lord Brooke, who at first did not recall being told, has been reminded of these meetings and has, with characteristic integrity, accepted that his memory must have been at fault. There's no more honourable or devoted servant than Lord Brooke.
The records are all there. The records.
It is also clear that when the Attorney General took his decision to authorise the offer of immunity from prosecution, he knew that the Home Secretary had been made aware of the matter. There was therefore no failure on the part of the Security Service to carry out their duty to inform the Home Secretary of these matters. It was for the Home Secretary to decide whether the Prime Minister should be informed. There is no record on this point, and neither Lord Brooke nor Lord Hume can recall discussing the matter. In the light of these events, I see no need to change the principles governing the relationships between the Security Service and ministers as set out in the Denning report. I think it right, however, that there should be a clear understanding among all those concerned about how we expect those principles to be applied. I have accordingly agreed with my right honourable friends, the Home Secretary and the Attorney General, that first, the Director General should report to the Home Secretary if he receives information about a present or former minister or senior public servant indicating that he may be or may have been a security risk, unless circumstances are so exceptional that he judges it necessary to report direct to the Prime Minister.